Okay, hi everybody. Thank you for joining us today, September 19th, as part of Conn Maciel Carey's Labor and Employment webinar series. We're going to be talking about the impact of workplace violence as it relates to both employment law and OSHA law. We've got two more webinars coming up for the remainder of the year. Next month we'll be talking about addressing employee complaints, and then in November we'll do our final webinar on dealing with issues relating to employment agreements with restrictive covenants, choice of law, and trade secrets. And you can register for those webinars on our website. But today's webinar, as I said, is about workplace violence. I am Conn Maciel. I am the founding partner of Conn Maciel Carey. I chair our labor and employment practice. I am physically headquartered in Washington, D.C., although I practice around the country, primarily advising employers, in all aspects of employment law, really the A to Z, from the hiring phase through the employment phase, and then through any separation or termination phase, and also defend employers in actions of discrimination or harassment and other kinds of cases. And here, with respect to workplace violence, I do a lot of advice and counsel on making sure that you're complying with the right state laws and federal laws as it relates to properly verifying that you have the right kind of employees in your workplace and how to investigate and respond to potential incidents of workplace violence if there's a concern. My partner, Andrew Sommer, is going to focus on OSHA, and I'll let you introduce him.
Hi, my name is Andrew Sommer. I'm a partner with Conn Maciel Carey's employment and workplace safety practice groups, where I practice throughout the state of California. I'm primarily based in San Francisco. I defend employers up and down the state in litigation involving employment-related claims. I also advise employers throughout the state on Cal OSHA claims and citations, and I also advise them throughout the investigations by Cal OSHA. I also work on Fed OSHA matters as well as other OSHA state plan matters, such as primarily matters on the West Coast. And in addition, I counsel employers on compliance with a myriad of employment laws, particularly those in California, as well as different local ordinances within the state that affect the employment relationship. I did want to first address the agenda for today. We have combined, somewhat uniquely, OSHA and general employment law issues together as they relate to workplace safety. And the first topic that we're going to cover is workplace violence and what that means, the common understanding and how it relates legally, as well as discussing OSHA implications of workplace violence. And then Kara is going to discuss employment implications of workplace violence and tips for preventing and responding to workplace violence. Now, as for the first topic, what is workplace violence? How is that understood legally? OSHA has developed guidance on this question, and the definition that OSHA has provided for workplace violence relates to any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that has some sort of nexus to the workplace. This definition is one that's been provided by OSHA, but certainly is a definition that we understand to encompass workplace violence in other contexts as we address this issue. And so OSHA does provide different examples of workplace violence. There's the commonly understood circumstances of a battery and assault. There can also be intimidation, situations of an active shooter, harassment. The workplace violence can manifest itself in a variety of different ways. There's different categories of perpetrators of these threats or acts of violence. First, starting off with employees, you can have a situation of a disgruntled current or former employee or a rejected job applicant. that engages in some sort of violent act. And there's certainly enough in the news that we hear about terminated employees, rejected applicants that come back, engage in an act of violence in the workplace. Nonetheless, there can be situations where there's an employee or a former employee that has no apparent sign or tendency of violence and that engages in some sort of violent act that is unanticipated under these circumstances. There can also be violence or threats of violence by third parties that may relate to employees. It could be the spouse or significant other of an employee. For example, an employee that's in the process of divorcing a spouse, and there may be a situation involving that spouse in the workplace. There are certainly situations that many of us have encountered where there's stalkers of employees, where there may need to be restraining orders. And then there's also situations involving, it can be a client, a patron, a vendor of your business that engages in some sort of violent behavior, and there may be no prior threat that would place you on notice of this. There's also situations involving strangers, and by this we mean individuals that have no connection to workers or the workplace. And if you have, for example, a convenience store, a gas station, there can be a situation where there's a robbery, or there can be a gang incident in the workplace. And as indicated, there's no kind of rational connection to your workplace here. We wanted to provide you some statistics regarding workplace violence, and these are somewhat alarming. The Bureau of Labor Statistics has compiled various statistics on violent crimes in the workplace. And first off, the Bureau has indicated that 18% of violent crimes are committed in the workplace. 21% of workplace crimes involve weapons, most often guns. And the Bureau has also found that of the workplace fatalities that are lodged, 10% roughly involved workplace homicides. And that's a real alarming number. And this explains why Fed OSHA and other state enforcement agencies have become more involved on workplace violence issues. And the statistics also indicate that the number two cause of workplace fatalities among female workers, the number two cause involves workplace incidents. Over 2 million employees report being victims of workplace violence incidents each year. And despite these statistics, fewer than 30% of private employers had workplace violence prevention programs, and only about 20% provided workplace violence prevention training. Now, here are some examples of areas where OSHA has become involved, and I will be discussing with you the basis under Fed OSHA for OSHA to cite employers over workplace violence incidents. But there's been a number of situations that come to mind. There's one involving a restaurant in Waco, Texas, where there was a biker gang meeting that led to a number of deaths. OSHA investigated, and I believe there were some citations that were issued. There was also an incident involving a TV journalist in Virginia killed by former coworkers. There's been incidents involving security guards, one particular involving a security guard killed by a patient under psychiatric observation. And a major focus of Fed OSHA has been on healthcare facilities as well as convenience stores and other retail locations where there is a propensity for violent incidents. And lastly, there was an incident involving a hospital in Massachusetts that was fined more than $200,000 by OSHA for alleged failure to abate violations for continued deficiencies in its workplace violence prevention program. But discussing briefly the mechanism that OSHA uses for citing employers for workplace violence incidents. There is no specific regulation that governs workplace violence under OSHA. Some states have been enacting standards for certain industries, but under OSHA there simply is none. This has not stood in the way of OSHA enforcing this issue. And what OSHA has done is they've relied on the general duty clause under Section 5A1 of the OSHA Act. And that general duty clause that can be applied in a variety of contexts states that employer has an obligation to provide employment in a place of employment that are free from recognized hazards that are causing or likely to cause death or serious physical harm. And here, the focus for OSHA is whether the hazard is recognized by the employer or its industry. So there's certainly industries where there is no recognized harm of physical or workplace violence generally. But others, particularly healthcare, particularly some retail settings, gasoline stations, areas like that, where OSHA has found a recognized hazard. And how they come to find this hazard is they look at whether that particular industry knows, I put that in quotation marks, of this hazard. And that can be by incidents that occur within that industry, publications in the industry, guidance that are offered for the industry. Other areas in which the OSHA can find a recognized hazard is to look at the 300 logs of incidents involving that particular employer, other incident records that might be on file with that employer, and workers' comp records, all to show that there's some sort of history of workplace violence that might cause OSHA to conclude that the employer should have recognized this hazard. And so, as I mentioned, there's industry consensus guidance. We can look at the employer's own policies on how they've addressed workplace violence to conclude whether there was a recognized employer hazard. And then, interestingly, OSHA refers to its own guidance, and where they've issued guidance, for example, for certain retail settings and for healthcare, they've used that to conclude that the employer should know that there is a hazard. And that's quite a flawed analysis by OSHA, because this is not rulemaking, this is merely guidance, and that's not to say that their own guidance should place employers on notice of a hazard. As I mentioned, OSHA has increasingly used guidance as a mechanism to address workplace violence issues, in part because there is no need for the proper notice and comment period to stakeholders for rulemaking. And there's no particular analysis that is in play. And under the Obama administration, there were a number of guidance documents that issued relatively informally, and that remain in effect under the Trump administration. All right, so moving down to is the workplace a recognized hazard? It's really important to look at the industry in which you practice. Even though you may not be on the list, there's no guarantee that OSHA would not find that there's a recognized hazard. But the areas that need to be acutely aware of this issue, at least from a OSHA compliance standpoint, involves healthcare, social services that has similar issues related to healthcare, where you may have patients with substance abuse or alcohol abuse issues or violent tendencies. You can have taxi cab drivers are subject to specific guidelines, and there's been issues of workplace violence in that industry as well. Any retail establishments that have late night operations there have been a higher percentage statistically of workplace violence incidences. And oftentimes we think of convenience stores, we think of gasoline stations that are open late and might not have very high staffing. And so in terms of addressing violence in retail, Fed OSHA has compiled statistics finding that 25% or more of workplace homicides occur in retail, mostly at convenience stores, gasoline stations, and liquor stores. And there are unique workplace violence risk factors for retailers. As I mentioned, there's situations of workers working alone in isolated work locations. There's the exchange of money, and that's certainly a situation at a gas station or convenience store. Sale of alcohol at a convenience store, that's an issue. And also areas where there's poorly lit stores and parking lot areas. There are recommended workplace violence prevention programs promulgated by OSHA. And in terms of the analysis that is recommended by Fed OSHA, they recommend that the employers in these retail locations identify and evaluate the risk factors that can give rise to a workplace violence situation, looking at the tasks that are being performed, situations that expose workers to the greatest risk of violent incidents, such as looking at the building layout, the interior, communication security systems. Are there alarms? Are there security guards? Are there ways for workers to alert the police or the company internally of incidents? And it's important for the retailers to evaluate the effectiveness of these existing security measures. As I indicated, there are also guidelines for the healthcare industry, and that also involves social services workers. And this has been an area that's been identified as a concern not only by Fed OSHA but by the states, and has resulted in California in particular promulgating a specific regulation for the healthcare industry that we'll discuss in a moment. These guidelines issued by Fed OSHA in particular are driven by concerns over the number of workplace violence incidents in hospitals, nursing homes, residential home health, assisted living, etc. The Bureau of Labor Standards statistics show that 70% of known workplace assaults occurred in healthcare. The new guidelines reflect research into the cause of workplace violence in the healthcare setting, risk factors from working with patients who display violence, and preventative measures that can be taken. Now, for addressing violence in healthcare, there are a number of recommended measures that can be taken. And these are addressed as well under the Cal OSHA standard. But the Fed OSHA guidance does refer to considering screening psychiatric patients for potential violence before admission, potentially using handheld metal detectors for concealed weapons, identifying risk factors involving that group of patients. Also, there is an emphasis on ensuring adequate number of properly trained security personnel are available to render assistance, and having potentially 24-hour security addressing or being ready to address any violent incidences in the hospital setting or other healthcare settings, and ensure that the security personnel are trained on identifying and addressing aggressive behavior, and that the employees as well are addressed on identifying this behavior, whether it arises from a patient that's being admitted or a third party. and also identify a system to flag patients, chart anytime history of act of violence is identified. Train staff to understand this system, to be able to address any potential issues with this patient set when violent incidences, at least a history of such, is identified. And then a key consideration is addressing the engineering controls in the workplace and ensuring that employees are not working alone or in secluded places with patients, and that there be sufficient architectural issues identified, including that they're not poorly lit areas, that there is a escape route that's available for employees, that there's not barriers that prevent visibility, for example, so that other employees can identify potential situations as they arise. Now, California has, its own regulation that specifically addresses this issue and is quite onerous. The Fed OSHA standard is a guideline, and it is, as a best practice perspective, important that at a minimum employers have a zero tolerance policy on workplace violence, regardless of your industry, and that then you consider, depending on your industry, developing a more beefed up policy and procedures that address potential workplace violence issues, and that you also engage in a process to identify and evaluate these workplace violence factors. Under California's new healthcare workplace violence prevention reg, there are specific guidelines or requirements that apply to the healthcare industry. Even if you're not in the healthcare industry in California, it's important to address these workplace violence incidences or issues, at least from the perspective by identifying and correcting the risk factors, because under the Injury and Illness Prevention Program, which is in effect in California and other plan states, an employer can be cited for not engaging in this risk identification and evaluation. But if you are in a healthcare facility, and under this California regulation, coverage applies to any facility, healthcare facility, essentially that involves treatment of injury or illness and involves admission for a 24-hour stay or longer. So this is hospitals, home health care, hospice, drug treatment programs, skilled nursing, assisted living. And so under this current regulation, these covered employers are required to evaluate and they're required to maintain a workplace violence logs and conduct training. But as of April of next year, of 2018, these employers will be required to create written workplace violence prevention programs that are quite onerous or require a number of different variables. And it is our recommendation that covered employers begin preparing these plans now, since there will be a number of variables involved, and there will be a requirement to train and implement the plan that will require some time. But just as a preview, some of the areas that are covered under this plan involve creating procedures for evaluating, identifying and evaluating environmental risk factors, looking at how employees work in the workplace, looking at engineering controls with the layout of the workplace, the lighting, how employees are interacting with patients, also looking at patient-specific risk factors in terms of the nature of the patient set, history of violence, whether they are being treated for alcohol or drug abuse issues, etc. And then also having a process for responding to incidents of workplace violence, not only identifying those potential incidences, but addressing them as they arise. Also looking at a procedure for ensuring that the facility reaches out to law enforcement and uses law enforcement as available for these incidences, and ensuring that there's proper training of supervisors and that employees are involved in the process of developing these workplace violence standards and are stakeholders as well. And then there are requirements for ensuring any investigation, correction of violence risk factors. There's a number of different variables that would require essentially a separate webinar, but this is something that employers should begin evaluating where you are covered under this regulation. Our firm does work with clients in preparing these workplace violence prevention plans. It's something that we certainly encourage you to develop soon before the regulation becomes effective in April, at least this requirement. Now lastly, the federal OSHA rulemaking has been essentially stalled on its own healthcare workplace violence standard. There was some movement under the Obama administration to develop a standard. There was lobbying from various labor groups. OSHA at one point in December of last year issued a request for information with responses due by April of this year, and information was received, and after the day before the end of the Obama administration, OSHA granted the union's petition to begin work on the federal workplace violence rule for the healthcare industry. But then just recently, the Trump administration has placed this potential rule on a long-term actions list, which essentially means it's indefinitely delayed, and there's no indication that it will be enacted anytime soon. So the takeaway here is that for now, from a Fed OSHA perspective, employers should expect that any enforcement actions will revolve around the general duty clause. And then if you are in a state where there is an injury and illness prevention program, you can expect those states to use those programs as a source for potentially citing employers for not addressing adequately workplace violence incidences. And now I will turn it over to Kara to address employment law considerations here.
Okay, thanks, Andrew. Yeah, so from an employment perspective, there are a lot of different types of legal claims that an employer can face as a result of workplace violence. I'm going to discuss in more detail the claims that employers and third parties can bring, but don't forget, too, that there are potential exposures from both the victim and even the accused or violent employee. So it's important to understand overall the legal risks from all the different angles, as it may be easier to quickly act to protect a victim while maybe overshadowing potential liability if you terminate or prematurely take action against the alleged perpetrator. So some of the potential liabilities, as Andrew has just adequately talked through, the OSHA general duty clause. We've got claims like vicarious liability, negligent hiring, supervision and retention claims, which I'll talk through. But from the individual employee, it's potentially failure to provide a harassment-free workplace if they make complaints and it wasn't thoroughly investigated or otherwise resolved. Potentially violation of an FMLA if the employee takes medical leave as a result of the workplace violence incident and something happens as it relates to that leave. It's got retaliation and whistleblowing claims. And then potentially the individual employee who's been accused depending on their mental condition or health condition. It could be disability discrimination under the ADA. If you are doing an investigation through your electronic emails to find out if someone has a history of violence or is engaging in harassing or violent behavior through emails, you could open your door to your policies on electronic surveillance and monitoring, depending on what your handbook policies say. And then again, if someone's terminated, depending on how that termination is communicated, we often see threatened claims of defamation and even wrongful termination in that sense. So just again, be cognizant that there are different levels and different angles of liability, and it's important to assess it from all different angles before making a final decision. So with respect to, though, your duties to employees and to third parties, recognize that under the vicarious liability and respondeat superior theory, there's generally no duty to control the conduct of another employee absent some special relationship, like an agency relationship. And that type of relationship does exist in an employment situation where the employee is acting as an agent for the employer for a limited purpose, depending on the job duties of that employee and what they are authorized to do during the working day. And so you have a duty as the employer to control the actions of your employees, particularly when those actions are within the scope of their employment. So think about if you have a driver and making sure that they're safely driving on the road, or if you have a security guard who has access to a gun or other weapons, making sure that that security guard is properly using those tools with respect to any type of enforcement, or again, maybe if you're in a retail and you've got somebody who is a theft, making sure that the security guard is properly controlling the actions, his or her actions. You can then, as a result, incur this type of common law liability, vicarious liability, if the employee is acting within his or her scope of employment, but generally not for acts considered outside the scope of employment. And I have to say that most acts of violence are considered outside the scope of their employment. You are not hiring somebody to commit violence or commit harassment or commit battery in the workplace to another coworker or to a customer or another third party. And so generally, courts have found that behavior to be outside the scope of the employment for purposes of vicarious liability, although there have been some circumstances where you are found to have a duty to control. So just sort of be aware of that scope of liability. The more common elements of liability that we see from plaintiffs is theories of negligent hiring, negligent supervision, and negligent retention. And here, you want to just understand that the allegation is that you have breached your duty to protect your employees and third parties from an injury because you should have known that an applicant or employee posed a risk of harm and was unfit, and therefore you shouldn't have hired them in the first place. As a result, you were negligent with respect to your hiring practices. And this kind of claim really goes to what type, if any, background checks did you perform? Did you contact prior employers to find out if the employee was eligible for rehire or had any tendency to violence in their old job? Did you check their references? Did you have a criminal background check policy? And if so, would that have, if that criminal record, would that have revealed some type of criminal background or propensity for violence? And it's really important, I'm going to talk at length a little bit later about background check policies, but it's really important that if you have one, be sure to follow it, because it could be really much worse from a legal perspective if you have a great background check policy, but then you don't use it or you don't follow up on it. So if you had one and you would have followed it and yet you didn't, and someone gets hired and they commit an act of violence, that can be a pretty bad fact for purposes of a negligent hiring claim. So make sure you're constantly reviewing your background check policies, and the employees that are tasked with administering it, they know what to do and they know how to make sure that they're complying with the law. The other third-party claim is a negligent supervision and retention, and this comes into play with respect to whether you or your supervisors or managers fail to exercise reasonable care when you're supervising an employee who may threaten coworkers or threaten guests or customers or somehow otherwise exhibits violent conduct. So, the questions there are, did you exercise ordinary care in supervising the employee? Was your negligence any type of proximate cause of resulting harm? And here, the key there is, does your managers and supervisors know or should have known of violent tendencies and then fail to take appropriate action? So did someone make a complaint of harassment, and how thorough was that internal investigation? Ultimately, what was the second act taken, and then did it happen again and it still wasn't addressed? The more times there might be complaints of threats or harassing behavior in the workplace or bullying behavior in the workplace, and it's not, steps aren't done to fully remediate it, then there's a more likely chance that you're going to be susceptible to a negligent supervision and negligent retention claim. So as Andrew talked about, it's really important to talk about having policies and practices and training in order to prevent and respond to workplace violence. I've been talking about this subject for a number of years, and I think in the very beginning, a lot of employers were hesitant about having a specific workplace policy, whether in their handbook or as a standalone policy, and just sort of addressed it otherwise through their anti-harassment policy. And then more employers started to create and expand into anti-bullying policies, even though that's not technically covered under federal law as a protected category. But as Andrew highlighted, not only you've got states like California that have regulations, you've got the OSHA's general duty clause. OSHA's investigating this and bringing claims. Now it's becoming more important to have a solid workplace violence policy, and that policy at a minimum should include a policy statement, a statement of prohibited conduct. You want to make sure you have a complaint procedure in there so people understand where they go and how they complain, if there's another neutral avenue. You want to include, of course, an anti-retaliation statement. And then if you have an EAP, employee assistance provider, that might be helpful too in order to have another third-party neutral person to report to or talk through. Other elements of a workplace violence policy could include signs of violent behavior, other information and links of resources that an employee can reach out to beyond the employer, contact information of building security, law enforcement, and then you want to make sure that this policy is consistent with and dovetails closely with your other policies that hopefully everybody has in your handbook. Hopefully everybody has a harassment policy. Hopefully everybody has a policy, a code of conduct policy, or just a general respect in the workplace policy. You may include, as I said, bullying in that particular policy. You may want to consider having a policy that governs the visitors in the workplace. Are they required to be accompanied by an employee? Are they required to wear badges? Are they restricted in certain access? Do you have, a locked door where you're only to come in with a badge or other things like that? So think through those various types of policies and talk through also sort of your training and your policies and procedures to make sure that they're all up to date. For example, are your emergency contact lists, are those all up to date? You want to make sure they are in case of an emergency. Do you have the right contact information if you need to contact family members of your employees? How are you going to communicate with employees if there is a violence act in the workplace and people have to be evacuated, for example? Do you have an understanding of the return to work procedures or something in place as to make sure everybody is safe and accounted for? How would you communicate that? Do you have a policy with respect to communicating with people via IM or email? Nowadays, we're seeing a lot of people communicating on Twitter or Facebook pages. Kind of just think through that in the event that people are not able to be in the workplace and you're trying to account for them externally or outside. Does everyone have access to company email account, even if they're not at work? For example, do they have remote availability at home? Or do you have access to your employees' personal email addresses that you can, again, contact them that way if you needed to? With respect to risk management and insurance review, think through whether there are applicable workplace violence insurance policies that may be available to you depending on your size. They can provide reimbursement for things such as counseling of employees post-incident, dealing with stalkers, independent security, PR in the event that something happens and you have to deal with the press and the media, and how to have a crisis communication plan with respect to that. Even could cover potential loss of business income if you're forced to shut down operations or a facility as a result of a workplace violence incident. Usually these policies are not too expensive, and they could also be tied to some of your other policies such as EPLI. In terms of your physical security review and assessment, you obviously want to be very aware of your surroundings, escape routes in your building facility security, and have a really good plan in case of an emergency. Look at the layout, the lighting. I know that Andrew touched on this, but in terms of making sure that you've got good industries with increased exposure like healthcare or late night retail, you want to make sure you've got good lighting, you've got people being able to move around, security cameras and communication systems. And then obviously once those policies and practices are developed and implemented and put in place, you have to train your employees on them. You've got to make sure that policies and your managers and your supervisors, they understand those and they're implementing them appropriately, particularly with respect to the policy concerning behavior, what's appropriate behavior, what's respectful behavior in the workplace. And then you want to keep records of all those trainings in the case you ever need to demonstrate to OSHA or to a third party or to a plaintiff that you have taken reasonable steps to protect against workplace violence. So it really is a team effort. It's not just an HR thing. And you may have challenges, for those of you that are in HR on the phone, selling kind of this idea to your C-suite, but it's really important that they understand that you need to get a team involved. It runs the gamut from your security, your facility personnel and management, the business team, the individuals who do training, if you outsource training potentially. You've got your CFO handling the financial aspects of it with respect to workers' comp or business disruption coverage. And then your intelligence, and this often comes in with your law enforcement or your background check companies. All of this should come together to make sure that they are part of a plan to prevent workplace violence. And there's different elements, again, as part of your prevention plan, that each of these issues you'll want to address. So I mentioned we talked about kind of employee background checks and how important that is with respect to a method of prevention for workplace violence, and particularly with respect to a claim for negligent hiring. Background checks can really run the gamut between criminal, credit checks, other types of things, and for purposes of this presentation, we're going to talk about criminal background checks. And we recommend that if you're going to do background checks, you complete the entire process in the application process before the employee actually starts work for a couple of reasons. First of all, you don't want anything to happen right away, so it's always practically important to have that completed. But really practically, it's much simpler not to begin employment with someone who hasn't passed scrutiny if you then have to terminate only a few days later. We had this situation recently for a school here in Washington where they conducted a background check, but it took a couple of weeks for that to come back, and DC in particular was a little slow with returning that information. The school went ahead and hired the employee pending the completion of the successful background check. The employee had started working with the kids, and there was no issue of violence once he started, but the background check did come back, and they did conclude that he was ineligible to remain employed. And it just was a sticky subject. They liked the employee, he was doing well, but because they had to follow their background check policy neutrally, they ultimately had to terminate the employee. And so it would have just been much simpler had they just not hired and allowed him to start work until the background check had been completed. Be aware, too, that if you're using a third party to perform your background checks, you've got to make sure you're complying with the Fair Credit Reporting Act. That's a very complicated law, and there's actually a new trend in class action lawsuits for not complying with the Fair Credit Reporting Act. So just be aware of that. I don't want to get into too much detail, but it really requires that there be proper notice in advance to employees and applicants before procuring the background check. And you've got to take certain steps if you're going to take adverse action against an applicant or employee as a result of the information that you may receive. As a result of that information, if you have questions about the Fair Credit Reporting Act, please contact Andrew or me, and we can give you more detail about that. And then be aware that if you do perform background checks, keep in mind that the EEOC is taking a position that not all prior convictions should be considered when making hiring decisions. You need to look at factors such as how long ago was the crime committed, the age of the person at the time of the crime, and how old is he or she now, whether the nature of the crime is job-related. And so it's really important that you engage in a balancing analysis prior to making a hiring decision. You have to be consistent and making sure that you're applying consistent factors across the board so that you're not running afoul of disparate impact claims for different decisions based for men or women, minorities or non-minorities, and you want to be consistent with the same type of criminal background. It's also important to know that the EEOC requires employers to treat arrests differently than convictions. According to the EEOC, taking an arrest history into consideration has a disparate impact on minorities who are more likely to get arrested even if the arrest doesn't result in convictions. And some states as well adjudicate that differently, and so you want to always make sure what your state law, ban-the-box law, is with respect to knowing when you can inquire or if you can inquire into arrest and or convictions. So that kind of leads me right into the ban-the-box movement. They've got a number of states and cities that have passed laws that limit an employer's ability to inquire about prior convictions at a certain point in the hiring process. You've got states like Massachusetts, Maryland, Rhode Island, Hawaii, cities like DC and Philadelphia and Newark. Generally, in those locations, you cannot ask about criminal history on the employment application. That's called banning the box, taking that inquiry off the employment application. Instead, you are allowed to do it later in the hiring process and at different stages depending on state or local law. Oftentimes, for example, here in DC, it has to be done after an offer, conditional offer of employment is made. So you need to go through the interview process, make a decision that you're going to hire this individual, and then you can do the criminal background check. Maryland, on the other hand, you can do it after the first interview process. So you really want to know what the law is in your jurisdiction about when and if you're able to inquire about criminal background checks. And oftentimes, they always have to be tied, the criminal conviction has to be tied to the job duties. So if you have someone who's convicted of a DUI, for example, and they're applying for a position that doesn't have any requirement to drive, query whether that is really legitimately job-related or not, or whether it's something that you can go ahead and proceed with the hiring process. Okay. So we talked a little bit about this, creating a standalone written workplace violence prevention program. Andrew mentioned this in terms of the guidance. So I think this is becoming more and more important, and more people are actually having this standalone written policy, and we recommend it. Again, zero tolerance for workplace violence, having workplace violence controls and a record keeping. And then, as I said earlier, you want to train your employees on that, having an action plan, having a reporting system, understanding what might trigger potential violent behavior, recognition of how things can be aggressive, how to de-escalate violent behavior. And there's some really great resources and trainers on how to respond to either an active shooter situation or just de-escalating a violent situation. So this is, think about whether you want to incorporate this in with your standard training that you do with your employees, and highly recommended, and again, can be used to help show that you are exercising reasonable care in addressing these kinds of concerns. Another main issue that sometimes people use is, are they going to consider pre-employment psychological testing on applicants in order to screen out potentially violent employees? And you want to be careful on a couple of fronts here. First of all, you want to look at potential disparate impact concerns, particularly under the ADA and even Title VII. Think about whether a type of test or the results of the test could have a disparate impact on minorities or certain type of employees with psychological disabilities. Generally, those tests are going to be okay if you can demonstrate that the test is job-related and consistent with business necessity. But there is a potential challenge to that defense, and whether there were other selection procedures that were equally effective but did not disproportionately exclude that group. And then second, you want to be aware that psychological tests that are designed to identify a mental disorder or impairment are considered a medical inquiry by the EEOC, and so you have to follow the EEOC's guidelines on that, where in contrast, a psychological test that measure personality traits, such as honesty or preferences or habits, are not considered medical inquiries, and you have much more flexibility in conducting those types of tests, either pre-employment or during employment. So think through, too, the impact of the Americans with Disabilities Act as to whether someone who might have a physical or mental disability, you're going to be required to make reasonable accommodations that are necessary to allow that person to perform their job. And medical inquiries at pre-employment can be used at that point to expose individuals to liability if they don't hire someone based on the results of some person's testing. For example, just even with respect to workplace violence, a violent employee could claim that his or her violent behavior is the result of an ADA-covered disability and is entitled to a reasonable accommodation. There's a lot of discussion about that. If someone, for example, is suicidal in the workplace and they engage with other coworkers on suicidal threats or tendencies, you want to think through whether you have a defense called the direct threat defense, and where you might, if they're direct threat to him or to others in the workplace, you would have the right to take action such as terminating that employee or placing them on a leave of absence until they can provide some kind of doctor's note or some other ability to show they can safely return to the workplace. But just be very, very careful. I do a lot of counseling in this regard with respect to somebody who's suicidal or has medical or mental health issues in the workplace, and you want to make sure that you have to base the adverse employment action on their conduct and not on their disability. Obviously, performance management that's detailed and timely is important, since many violent employees are reacting to what they may see as unfair treatment, whether that's discipline or recent coach and counseling. So just make sure that you're always giving consistent, fair performance feedback that's timely, and therefore they're less likely to react negatively. So the last few slides I want to get to before we open it up for questions is knowing the profile of a potentially violent employee. There's no checklist that anyone can anticipate in all situations. And some situations come on very quickly. They may be hard to assess. But here are some common signs with respect to what someone might be a profile of a violent employee. You've got, someone who is a long-time employee who depends on the job for self-esteem, a loner or with few outside interests, someone who's disgruntled, who blames others for problems. That's really, think through someone who wants to be in control. Someone who's violent often has a desire for notoriety because of feelings of humiliation or rejection. They're moody or unpleasant. They've got stress in their life. They feel like they play the role of the victim. Certainly fascination with weapons and their killing power is a red sign, particularly someone with no previous interest in guns or weapons, if it's something that's new. So just be aware of that. And the most important people to highlight these kind of signs are bystanders, whether it's your coworkers, your managers, your guests or customers to your place of business. Those are the best people to identify and prevent workplace violence. You want to be aware of the warning signs and make sure you have an opportunity to report it, and that once it's reported, it's investigated. A lot of times people who observe these types of warning signs and disruptive behavior, they just don't know how to respond to it. Or even they say, well, that's Joe being Joe, and they don't address it appropriately. Here's some behavioral signs that could precede a violent act. Someone who's explained increase in absenteeism. This is someone seeking privacy. Oftentimes it's cocooning to prepare themselves, either mentally or physically. suffering extreme humiliation or rejection, heightened verbal threats or physical acts. One of the last signs is this legacy token. This is about leaking behaviors on social media. They're talking to colleagues. They're creating a video or some type of manifesto about an attack. Social media has been used very effectively, and as coworkers or friends with other coworkers on social media, that's another way that could be one of the last warning signs before a potential action. And then be aware, too, of the importance of your open door policy and even litigation. I know no one wants to face an employment litigation or wrongful termination claim, but using those types of avenues is a much better nonviolent reaction to criticism or performance, and that's much better than violence. And then finally, what else can you do when faced with an imminent threat of workplace violence? The FBI has a behavioral analysis unit, and it's really key. You can call them for guidance. They have a specialized team that they can send people to your work site, can give you advice and counsel over the phone. They have a clinical mental health unit, and they'll work with you to conduct a threat assessment. They'll have a key team put in place, and what they really do is they do sort of an individualized and then a holistic view of the employee to assess the level of concern. So just understand that that's an option if we really are fearful that there might be something serious coming. And then there's always, the option of obtaining a restraining order. That really depends on state law. So if that's an issue, we want to look at the various state that you're in terms of when and whether an employer is allowed to seek a restraining order against someone from entering the workplace or contacting employees. So I see that we're right at our time. I know that was a lot of information. I want to make sure everybody is aware of our two blogs that we regularly update and talk about key trending issues, and happy to address any questions. And we have one question that's been posted, and let me see if I happened to answer this when I was on the call. With the Ban the Box movement underway and the desire to have employers be more open to giving candidates with felony convictions a second chance, how does that sync up with the potential for negligent hiring risks? And that's, again, a great question. I think that really goes to what the EEOC, too, also really wants in terms of having this back and forth analysis and evaluation into, okay, well, how long ago was the felony conviction? If it was 10, 15, 25 years ago, great reason to give that person a second chance. And again, the potential for negligent hiring would be minimized because you've looked into it, you've done an analysis, it was a long time ago, and the person has exhibited characteristics of being rehabilitated, and you can establish that through your documentation. If the felony conviction was again, not related to the job duty, that also, or maybe not even a violent felony. It could be, a financial felony or something like that. That also would mitigate against a negligent hiring risk. So just overall conducting an analysis and understanding what the conviction is, how recent was it, what the relation is to the job, that will help mitigate against any negligent hiring risk in the future.
And I would add to that in San Francisco we do have a ban the box ordinance, and I've had issues with clients in this area where I've advised essentially that if you have a position where there is a heightened risk of workplace violence or risk factors, then what you do is you conduct the background check or inquiry to the full extent allowed under the local ordinance, and that would be a reasonable effort since obviously you can't go beyond that. But there are exceptions under the Ban the Box ordinance for certain industries where you are required to engage or conduct government required background checks, such as in healthcare or social services. But if you're conducting the background check to the full extent allowed under the law, that's certainly something you can rely upon as diligent efforts.
Andrew, a couple questions have come in that I think might be good for you. These are really great on the issues of online or cyberbullying on social media, whether after hours, between coworkers. Does that fall under the general OSHA clause?
Well, if there is some sort of nexus to the workplace, there could be an argument that it would fall under the general duty clause or other applicable requirements. But so the question would be if there is, if for example there are harassing communications among employees through the email system at work. And for example, say one of the communications involves a threat of violence, that would certainly be an issue that could trigger certain legal responsibilities, including under the general duty clause.
And two, I mean, also think through how much are you aware of it. If it's private social media sites, whether Twitter or Facebook, and you have no knowledge of it, how much can you be responsible? But if someone has brought forward a complaint, whether it's after hours or not, or whether it's during the weekend, it's still important for you to conduct an investigation and try and address that bullying, whether it's cyberbullying or in-person bullying.
And there is a question about how do you suggest employers to include cyberbullying in workplace prevention programs. I, for example, always encourage clients with harassment policies to include a component that involves cyberbullying/harassment, and that is an area that certainly can be addressed there, as well as a component under a separate zero-tolerance workplace violence policy.
And Andrew, I know in California you have a required harassment training under state law, and as part of that training, when you conduct it for California employers, do you include an aspect of cyberbullying and issues touching the workplace violence prevention program?
Right. That training requirement is for supervisors, and when I've conducted that training, I'll typically address an awareness of the same issues of harassment that occur in verbal communications that they would apply to any electronic communications, and to be aware of that as well.
Great. Any other questions for those on the line? As I mentioned at the very beginning, this has been recorded, so we will circulate the recording as well as all the slides after the webinar concludes today, but we appreciate everyone's time and attention. We hope you found the information useful and you've got some really good tips to go back to your workplaces, and if you need assistance with developing any kind of policies or programs or training, please don't hesitate to reach out to Andrew or I. This is what we love to do, and we'd be happy to partner with you and help. Thank you, everyone. Bye-bye.
Thank you.